Good morning, Mr. Toomey.
May it please the Court, my name is James Toomey. I represent the Town of Hingham and the Zoning Board of Appeals of Hingham. The case before the Court today involves a dispute between the town, the Zoning Board, and the Department of Housing and Community Development as a result of a November 16th, 2005 ruling by the DHCD.
Mr. Toomey,
Yes, Your Honor.
Is that November 16th, 2005 ruling anywhere in the record?
It is not, Your Honor. This was decided on a Rule 12 motion. It is covered at page 16 of the complaint
I
where...
appreciate that it's referred to, but it would be helpful to have it.
Well, unfortunately, we did not include it in the complaint when we were pleading the case, Your Honor, and I agree. I would have liked to have had it, but we don't. It's not part of the record. But that letter provided that only 25% of the housing units in the Linden Ponds development project would be counted as affordable for purposes of Chapter 40B, whereas the town maintained that that count should have been 100% of the units as being affordable. The basis of the town's underlying complaint is that the DHC decision violated its own rules that an affordable rental project in a rental project, all units should be classified as affordable as opposed to just the ones that are affordable. The result of the Department of Housing decision is to undercount the number of affordable units in Hingham and deprive the town of the credit it's legally entitled to for affordable units.
Now, I take it you made this argument to DHCD, right? You said, whoa, we have this, or either before the letter or after the letter. You've made this argument to DHCD.
Certainly did, Your Honor. That's what resulted in the letter.
All right. So they've rejected your argument.
Correct.
Consequently, they will not put 100% of the units on the SHI, the subsidized housing inventory.
That's why we're here.
And that is not a final ruling with respect to whether you've met your 10% requirement, is it?
Well, it is a final ruling as to the town.
Well, how is
and
it
that's why that's the nub of this case.
How is it a final ruling as to the town?
It's a final ruling as to the town because the town has no ability to obtain review of that
well, it has
decision
the,
independently.
Of course you do.
At the end.
You have an ability to obtain review of it when you get another comprehensive permit application, and let's assume you deny it because you say you're over the 10% limit, and it goes to the Housing Appeals Committee, and you get to have an adjudication of whether you are or aren't over
Well,
that 10%.
that makes a lot of assumptions, Your Honor. It makes the assumption, first of all, that there's a case that the town feels warrants being rejected at its level.
If not, why is this right?
It is right because the subsidized housing inventory number is not a theoretical number that stands up there. It is one on which basis.
The subsidized housing number, the 10%.
No, that's it.
That doesn't mean to say that the case law is now clear that even if a town has achieved its 10% goal, it doesn't obliterate the use of a comprehensive zoning permit.
That's correct.
So, developer, Hawthorne Ponds comes in and says, I want to use the comprehensive zoning permit route. The town could either say, sure, regardless of the 10%, or it could say, actually, no, we are not going to use that comprehensive permit at all because we've met our 10% and we don't like it. Fair point for a particular town. That decision then provides the vehicle for review. So the town hasn't suffered any injury at the present time.
Well, I would disagree, Your Honor. First of all, you're right. What happens, that 10% converts what would be a mandatory program of exempting local regulations to a discretionary one. And the point, however, is that the town cannot force that appeal. The town has no ability to say to the developer, we're going to deny you because we think you're above 10%, and you have to enforce the appeal. So again, the town...
So what?
So if there's no appeal, you've got no injury. You didn't want it, you don't have it.
Well, the injury, yes, we do, and that's the point. The subsidized housing inventory is not something that's a theoretical number out there. It's a status on which people base their conduct. people decide to do or not to do developments, make other decisions within the town.
You're the town.
Well, and we make decisions in the town. The town is in the business today of creating affordable housing.
But
Yes,
Mr.
but that's-
Toomey, let me ask you this. If each municipality could challenge the SHI each time it's issued, twice a year, I believe, wouldn't the courts be flooded with lawsuits?
Only if there's a basis to challenge that number, Your Honor. And I don't see that's going to happen with that kind of regularity.
To Toomey, can we just go back to the injury?
Yes,
Okay.
Your Honor.
So the town says we've met the 10%. Is this the Linden Ponds?
It is,
Yeah.
Your Honor.
Okay. The town says we've met the 10%. We've approved Linden Ponds, and we're including all the units. And the department disagrees.
Yes, Your Honor.
Okay, so Hingham doesn't know for sure.
Correct.
Hingham can do one of three things. It can continue to build affordable housing because it's interested in affordable housing.
That's correct.
Whether or not somebody wants a comprehensive zoning permit, that was your last hypothesis, it can go ahead and do that. The department isn't going to stop that. It could consider a request from a developer to use the comprehensive zoning permit route, and it could go along with that because it just thinks that the comprehensive zoning permit route is a good way to go.
Correct.
Or it could deny it because it doesn't think it's a good way to do it, and it doesn't want to have this kind of development using a comprehensive zoning permit. So it denies it on that basis. Then one of two things happens. The developer appeals, no problem, the issue gets resolved, or the developer doesn't appeal, and Hingham has got what it wanted, namely no development under the comprehensive zoning permit. Where's the harm?
Well, the harm is in the process, Your Honor, before you get to that point, because the town has to look at each of these cases that comes before them, and entails a great deal of expense in terms of processing the cases, the time it takes the municipal agencies
But there will be no
through.
processing if the town wants to turn it down because of 10%. That's the only time the town is at risk. There's no processing. It simply says to the developer when it walks in the door, I want a comprehensive zoning permit. No, because we don't have 10%.
But that is not, that sounds good in theory, Your Honor. That's not the way these cases are evaluated. The town zoning board is going to look not only at the issue of the 10%, they're going to look at the merits of the project, because they do have the discretionary authority to approve these. So they have to make an evaluation not knowing whether the 10%
What
is a
difference does
rule
it
for
make
them.
if they're going to really look at it on the merits? Right?
They can.
Yeah, what difference does
What difference does it make?
Couldn't
Because they can, if they couldn't do it under the comprehensive zoning permit, I could understand your argument. But we've said that they can.
They can.
Couldn't they allow it on the basis with a condition that all the units are to be considered low to moderate income housing, and if not, otherwise denied?
They could.
And then you got an appeal to the HAC, your issue gets fully litigated there, and then Superior Court, and then here.
Well, yeah, but the difficulty with that, Your Honor, is you have to wait for all of that process while you've got these cases being processed
But
in the
the
meantime.
statute wants expedition. The statute wants expedition.
Well,
in
I
handling
would
these
suggest
cases.
you don't get expedition. That's why you have a Declaratory Judgment Act. You have a right on one side, a status. You have a contrary claim on the other side. And the whole purpose of the Declaratory Judgment Statute is to allow those rights to be declared before you have to
But
make
this would be
decisions that put people at
This would be
risk.
the same as saying in any other agency hearing, you can detach or pick off one preliminary issue, admittedly an important issue, and have it fully litigated.
Well,
And the
but
answer is
I think
no.
that's a good point, Your Honor, and I think that's where the trial court goes wrong, and I think that's where the Attorney General goes wrong in relying on the Samuels cases, the Walpole case, the Marion case. All of those cases are ongoing proceedings where the parties are engaged in the proceeding, and one of the parties comes out to the court and says, give us a preliminary ruling on this.
Well, that's
In-
exactly what you're asking
It's,
for.
no, we aren't, because we are not part of an ongoing proceeding. We
So
can,
it's worse.
so, because,
from that
because we
perspective.
don't have the ability to go and get that. That's why we have the declaratory judgment statute, Your Honor. When you have these issues of rights, you're about to make decisions which affect people's activities, and you don't have the ability
Mr.
to
Toomey,
get an answer on that.
usually what the I'm not saying this is a univote, but usually what the Declaratory Judgment Act is used for is when somebody is going to affirmatively do something, that if they did it and they know that there's a claim out there, for example, I'm about to use this kind of billboard, but I know there's a claim out there that that'll somehow impinge on the trademark of somebody else, or I'm about to build a house, but I think it seems to me that the town isn't affirmatively doing anything here.
Well, but the question is, the town is going to affirmatively do something. The question is getting guidance on what they can and cannot do. I'd point you to, there's a case, McCaffrey versus the School Committee of Haverhill. And that was an issue where you had a superintendent of schools and an assistant superintendent of schools. And the question was, had their employment been created in such a way as to create tenure? There was no dispute at the time of an ongoing effort to change that employment at all. And this court said, that's an example of where someone is making a claim of legal status. And
But
the
of course, in that case, if it isn't creating tenure, you may want to look for a job elsewhere. Can I go back to Justice Cowan's, I think it was Justice Cowan's question, where she said, if we were to say that the declaratory judgment statute was appropriate in these circumstances, what would prevent just endless lawsuits of declaratory judgment? Your answer was, well, there would have to be some basis, but as you know, there are lots of disagreements between towns and the department at the 10% mark. When do you calculate? I mean, I think we've got at least 6 cases on this month, and we may have more. So why
would we have the endless number of cases? One, how many instances would occur where you'd have to be at the 10% threshold would have to be an issue.
Well, as time goes by, more and more are going to be right at the 10%.
And then you'd have to have a meritorious claim with respect to what's wrong with that count. And
so just arguably, if you were allowed to proceed with the declaratory judgment action, are you contending that could put a hold on any applications for comprehensive permits that were filed with the town?
if we were to succeed in the 10% count, Your Honor?
No.
No, why,
While you're litigating the declaratory judgment, are you claiming that you could put a hold on?
No, they're being processed.
So you run the risk, you acknowledge that if we go your way on this, that you run the risk that you may be wrong and that towns may have filed, or developers may have filed applications under 40B that could get decided before your declaratory judgment case gets decided.
That's correct. That is likely to happen in terms of there are cases pending now.
Why can't you raise the issue in one of those cases?
Because it may not pertain to those particular cases that are before the board. They may be meritorious projects which they want to present.
Of course, the projects may be.
And the other issue is, should the town do that? If the town doesn't know whether its 10% argument is a good one or not, it's taking on legal liability that it would not otherwise have to take. And that's the reason for the town to find this out, so it can shape its behavior.
Mr. Toomey, the second part I may have understood, but the first part is whether or not a project is meritorious seems to me to be entirely beside the point, because the town can always, I mean, is the town getting any pressure that it shouldn't use the comprehensive zoning permit route even if it wants to?
Well, there's always going to be someone in the community, but I can't say that's not part of the record here, and I'm not saying that's what motivates this case.
It seems to me that the comprehensive zoning permit may be a very good way for the town to decide how to go. In any event, I mean, this is not a bad way to do it, right? So the town can always decide to do that.
It can, but in terms of processing the cases that have before, it does not know what its options are.
Let me go to your harm. The town is going to have to litigate the town is going to have to litigate, in this case, under the declaratory judgment, or it's going to deny a permit because it claims that it has met the 10% requirement of the subsidized housing inventory. It denies a developer a comprehensive zoning permit because it doesn't have to do that. And essentially, you're going to litigate on that basis. Why is that any more expensive to the town to do it later rather than earlier?
Well, because you have that process that goes on, which entails a lengthy hearing process.
But
As
you
can see-
don't even have the lengthy hearing process. You just say right off the bat, a developer walks in and says, I want to go through a comprehensive zoning permit route, and the town says right off the bat, we're not doing that because we've met our 10%.
But the town is not in the business of trying to set that up in those hearings, Your Honor. The town is in the business of trying to approach these hearings in a thoughtful way and hear what the developer has to say. If someone wants to present them, the town wants to hear what they have to say. It may be meritorious, may not be meritorious. It may be something that can be negotiated somewhere in between what's initially presented and what comes out in the end. The town needs to know whether it has the 10% rule in its arsenal of tools to work with as it goes through that process. And that's what we're suggesting is a legal right that we have
Yeah,
here.
but isn't that akin in any lawsuit? There are evidentiary rulings that are going to be made along the way, and a party will be stronger or weaker if the ruling is made for or against it, and wishes that it knew ahead of time how the judge is going to rule. You can't come into court ahead of time. Sometimes you can on a motion to eliminate, but you certainly can't appeal and get an adjudication ahead of time, and that will make that will have a great impact on how the party will proceed in settlement negotiations, et cetera, et cetera.
But that's the Samuels case, Your Honor, where someone comes in an ongoing proceeding, adjudicating that, and comes in and asks for an advance ruling, where the two parties to the case are in an ongoing proceeding in which one person tries to get what effectively is an interlocutory ruling. That is not the case here. We are not in a proceeding with the DHCD at this point, and that's why this comes into the declaratory judgment statute and is one where you would, the declaratory statute would allow you to have an advance ruling. It's the very case that the that the declaratory judgment statute is written for.
Thank you, Mr. Turner.
Thank you, Your Honor.
Ms. Schiff?
Thank you, Your Honor. May it please the Court, Assistant Attorney General Soo-Kyung Shin on behalf of the Department of Housing and Community Development. This case can be resolved by applying the settled rule that an informal, non-final agency action does not create an actual controversy under the declaratory judgment statute.
What's the harm? What's the harm? Why can't they come into court? I mean, it's not as if they don't have some agency action. Some agency has said to them, you haven't met your 10%. So what's the harm? I mean, these are often volunteers out there. They're doing tough work. I mean, building, developing. We're trying to get these things resolved as fast as possible. Why can't they come in? It's quick, easy. There's only one issue, right?
Right, Your Honor. I would have two responses to that. First of all, as Your Honors have already noted, if Hingham's position is adopted, the department could potentially be subject to hundreds of lawsuits every year.
Well, it hasn't been so far.
It hasn't been so far, but as the towns are getting closer and closer to the 10% threshold.
So we'll deal with that in due course. If it turns out you've got hundreds, maybe there'll be some guidance along the way. This regulation where they've got, 25%, and the town says we want to count 125 units, and the town wants to count 100 units, that one's resolved. So that takes care of all of those cases.
But this flies in the face of settled administrative law that says you cannot break out part of an administrative proceeding that's preliminary in nature and appeal on it. Declaratory judgment doesn't lie to fix that.
But the parties aren't engaged here.
They're not engaged, Your Honor, but I would submit that makes it even
I understand.
the controversy even more speculative.
But why is it speculative? There's a controversy between the department and the town as to how many...
How to count the units.
Yeah.
Because the SHI calculation it's just a preliminary non-final action, and by regulation, first of all, it's created by the agency, and contrary to...
If they go back If they go back, this agency's not going to change its mind. If it did, it'll be...
But they're entitled, they could have a hearing where the Housing Appeals Committee is going to look at every unit and decide whether it does or doesn't fit on that SHI, right?
That's correct, Your
Which
Honor.
hasn't happened.
If the issue comes up later in some concrete posture and the SHI is challenged either by the town or a developer for that matter, then by regulation, the committee must determine on a case-by-case basis what housing or
Well,
units
that's
it
certainly
constitutes.
one way that it could happen. But doesn't declaratory, we've never said, I don't think, that declaratory judgment is only available where there's no other remedy.
Quite the contrary. Quite the contrary. What if the town engages, a developer comes in, okay, a developer comes in and has done a lot of work, expended a huge amount of time, in all kinds of, water table investigations and wells and so on and so forth, and comes in with a proposal, and the town says, for a comprehensive zoning permit, and the town says, sorry, you don't meet the 10% ruling. Okay?
Okay.
And that's appealed, and it turns out the town was wrong. Damages to the developer because, oh, by the way, when was this first comprehensive zoning permit sought?
I believe it was 2001.
Do you want to guesstimate what the increase in the cost of the project is between 2001 and 2008?
I couldn't guesstimate that, Your Honor.
I would say it's substantial. Would you
Sure.
agree it's substantial? Substantial. And we've delayed, whereas if the town, in a very straightforward, short, cut to the chase, could just go in and say, just on this calculation, correct or incorrect, that'll probably take, maybe 18 months.
Well,
And then the town knows what it's doing. Would it be open to damages for delay?
well, I would disagree with
Would the town be open to damages?
the town be open
I
to
don't think
damages.
so.
Okay, the town may not be liable for damages. Do you think the developer might go away and we might lose affordable housing? Because the developer, it will be very clear to the developer that Hingham doesn't have a 10%, has met its 10%, and so it may go to another community.
Actually, Your Honor, I think the opposite is true. If Hingham's position in this case is adopted, that is what would chill the creation of more affordable housing. And the reason for that is this. What Hingham has carefully avoided mentioning is what would happen if this case were allowed to go forward. And that is because if this case goes forward, and even if Hingham prevails, that would not conclusively resolve anything either. Because the SHI is a creature of regulation, and by regulation it carries only a presumption of a correctness, the only effect of a declaratory judgment in Hingham's favor would be simply to attach that presumption of correctness to a different SHI calculation. And that is to say, the SHI, if Hingham wins, were now to be changed to include the 1,750 Linden Ponds units, but that number by regulation would still carry only a presumption of correctness, and that presumption would still be rebuttable in any later committee proceeding. So the uncertainty that the town complains of would exist whether or not this case goes forward.
But that presumption of correctness is extremely important to all of the parties in any proceeding, because presumably a developer is not going to press forward if the presumption is that the town has met the 10% equivalent ceiling. And if the presumption is the other way, then the town is going to understands that it's at serious jeopardy if it simply denies it on the basis that it's met the 10% challenge. So it has a real impact. It is not a fantasy or a possibility. It's real.
It does have an impact, Your Honor, but as this court has made clear, a declaratory judgment action is not a mechanism to secure an advanced evidentiary ruling. And
It's not an advanced evidentiary ruling. I understand the case law very well, of course. And what's at issue here, though, is whether the department, which is the state agency charged with determining whether or not these quite onerous changes to how zoning approvals used to operate. And the comprehensive zoning permit really shook up the way zoning approvals occurred, whether or not a town has any obligation to continue down that path. And it seems to me that that's such a go, no-go decision. that it's not like some kind of evidentiary ruling. It's from the get-go a go, no-go.
But again, Your Honor, I would submit that even if Hingham were to secure the relief that it seeks, the only effect of that would be to shift the presumption of correctness to the new SHI calculation. So in effect, all that Hingham is seeking in this case is a decision that would flip the presumption in its favor and thereby shift the evidentiary burden to the developer if there's any later proceeding
But as
before the
Justice
committee.
Cordes, and I won't repeat it, has just said, that has a real-world impact, both for the town, because if there's a presumption that Hingham is incorrect, the town knows that it's proceeding at its risk. On the other hand, if the presumption is correct, that the 10% has been met, then the developer knows that it's proceeding.
That's true, Your Honor, but nevertheless, the SHI calculation is not binding on the committee, and also there could be other units included in the SHI that either the town, or more likely the developer, would want to challenge the inclusion of those units. So it's not solely limited, the 10% issue is not exclusively limited to whether these particular units should be included on the SHI. And going back to the unnecessary litigation point, I did want to correct an error in the briefs on this issue. The SHI is formally issued once every 2 years, and on pages 25 to 26 in Hingham's brief, it states that the SHI is issued twice a year, and I repeat the statement on page 22 of my brief, and it's actually issued biennially by regulation, or once every 2 years.
How does that, what does that mean then? What's the effect of this delay of this 2-year annual SHI? So in the interim, if the SHI is published on day 1, then the presumption of correctness goes with whatever they say on day 1, and that presumption is the presumption for 2 more years, even though there may be a lot of construction within that?
No, Your Honor. The SHI is formally and comprehensively issued once every 2 years, and then it's sent out to 350 towns, but it is informally updated on the department's website.
Informally,
in the sense that I take it the town's notified.
Yes, on a more or less continual basis. In practice, each time a comprehensive permit is issued, the town, whichever town it is, will notify the department and seek inclusion of those units on the SHI, and then SHI will agree or disagree. So it is updated more or less on a continual basis. But in any event, if Hingham's position is adopted, then each one of these some 350 towns could challenge the SHI each time it is revised. And I would submit that if the towns can challenge the SHI, then so too could developers who believe that certain units have been wrongly included on the SHI. Hingham would therefore have the department defend potentially hundreds of lawsuits every year that seek to do nothing more than challenge an interim determination made by the department, and even though that determination would not even be binding on the Housing Appeals Committee.
Yes. I should have asked this of Mr. Tony, but since you're there, there's something in the record that there is pending before, or there was at the time of the Superior Court proceeding, there's pending before the ZBA a new application. Can you tell me something about that?
Sure, Your Honor. Hingham had filed a motion to supplement its opposition to my motion to dismiss, and attached to that motion was an affidavit of a ZBA member stating that there was a pending application before the ZBA. And the Superior Court did not act on that motion to supplement, so technically...
So it just simply said there, it didn't describe it at all, just said there is one pending?
I think there is some description of it, but since the court did not act on that motion, technically the affidavit is not part of the record, and if there's no evidence of a pending application, then I would submit there's most definitely no case or controversy. However, in the interest of economy, the department does not object to the court proceeding and deciding the appeal on the presumption that there is a pending application, assuming that's still true. Otherwise, I assume the town will just simply refile its complaint with added allegations. And also, I'd submit it doesn't matter, because even if the court does accept that there is an application pending, there'd still be no actual controversy for all the reasons.
If Hingham prevails,
Yes.
I take it would be worse than every 2 years some cities and towns might challenge their SHI numbers. I assume it would mean that they could challenge that at any time. Any time they've approved a comprehensive permit and they don't get the number of units that they thought they were going to get, I assume they could then bring a declaratory judgment action if Hingham prevails. Right?
I think that's true, Your Honor, and I think
And any developer could
a
do
developer
the same
could
thing.
as well, exactly.
But a developer could do it even if they weren't the subject of the comprehensive permit.
Correct.
In
A
other words,
developer's in the plans, has plans to propose a new project, and there's
And wants certainty as to
Right.
whether the SHI is correct, so they could just bring that action.
The flip side of Hingham.
Right.
correct.
What do you say, you know the Rentham case?
Yes, Your Honor.
How does this, I take it your position is even if the hypothetical is that Mr. Toomey's client had denied a permit on the basis that it asserts it has 10%, it has reached the 10% mark. That's the basis of the denial. Housing Appeals Committee says you're wrong and remands it back. Your position is still that's not final either?
No, and that is getting into the issues presented by the Rentham case. But no, I would submit it's simply, allowing the committee to apply its expertise to the question in the first
Is
instance.
it final?
It would not be final. It would be in the nature of an improper interlocutory. And the committee could very well agree with the town, in which case this appeal would be moot. But if the committee disagrees, then after the town holds a comprehensive hearing required by the statute, it can then take the entire case up to the committee and then to the Superior Court under the usual avenues of appellate review. I see I'm almost out of time, but I did want to address briefly, because my brother has focused so much on the merits in his brief, even though the merits are not at issue in this case, I do want to note that if given the opportunity, the department is fully prepared to show that its determination in this case was eminently reasonable. And to summarize the department's position, the department believes that Linden Ponds is not a rental development because it requires entrance deposits ranging from $195,000 to $435,000,
we understand.
along with the monthly fee.
Thank you.
Thank you, Ms. Shin.